on a second. We got this going on. So I'll finish that later, or maybe not. Y'all know who the rest of them were. The Mattingly, and then Kaya, the Akai, I can't say his name.
All right, good morning, everyone. We are back on the record on case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. The jury is not present at this time. The court took under advisement separate motions yesterday relating to victim designations, as well as 2 motions in limine, and set aside time this morning to make rulings on the record on those motions. So I'll note the defendant is present, as well as defense counsel, the state present as well, prosecutors, and the court resolved the victim matter on the record yesterday. I do have rulings as it relates to the motions in limine this morning. So again, there were 2 motions filed, one on March 4th, one on March 14th by the state seeking introduction of statements that may be hearsay or may not. That's what was argued in the motion, and whether or not they'd be admissible. In terms of what is hearsay or is it hearsay, the Idaho Rules of Evidence define hearsay as a statement, oral or written, other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. That quotes Idaho Rule of Evidence 801 A and C, and from a case Sandoval Tana 138 Idaho 911. The evidence has been objected to by the defense, and so there's a question for the court to resolve of whether or not this is inadmissible hearsay. There are general exceptions to some of the hearsay statements that are in the rules, and the court has to analyze those looking at rules 802, 803, and 804. And then so the court has to first determine whether statements are in fact hearsay, and second, whether there's any exception that allows them to be admitted. So the first matter we'll take up is the statement requested by the state in the first motion in limine filed March 4th. That is a statement of Janice Olson, and the state seeks to introduce an out-of-court statement made by Tammy Daybell to a coworker and friend, Janice Olson, somewhere around 6 weeks before the time Tammy Daybell passed away. The statement that the state seeks to introduce is quoted in the motion. That was a statement Tammy allegedly made to Janice Olson, quote, she would just, I'll read that again, quote, she would, comma, she'd just say, comma, my husband thinks I should up my insurance here at the end of my, comma, at the end of my career, comma, before I retire. He's thinking I should up my insurance. The state seeks to introduce that statement, has argued that a exception would apply permitting that under Rule 803.3. And under 803.3, that allows for statements that are citing from the rule then existing mental emotional conditions. And the state's argued that these would fit within a physical condition statement talking about the health of Tammy Daybell at the time, and the state arguing that her health is something that goes to the statement, bringing it within 803.3 for that part of the exception, which does allow a statement such as bodily health is what's included in the rule, and a statement of the declarant's then existing physical condition. The defense argued against it, saying it simply talks about a financial decision that was being discussed and does not fit within 803.3. The court did some research on the issue in 803. There's a case, State of Idaho versus Garcia, 102 Idaho 378, and talks about when 8033 may apply. Talks about four areas. One, claims when there's claims of self-defense as a justification for killing, that would not apply here. Two is if there's a defense around a suicide allegation, that would not apply here. Three, claims killing was accidental, which there's no evidence that's in the theory of the case of either party here. And then four, when a specific mens rea is in issue. That specific mens rea issue in the conspiracy could be considered. However, upon weighing things out, both under 8033 and also under Rule 403, the court finds the statement is problematic for a few reasons. Number one, just reading through the statement again and precisely what the statement is, this talks about Tammy saying, quote, "My husband thinks I should up my insurance at the end of my career before I retire." And so first of all, there's an issue there with when that would occur. There's some vagueness there. The testimony in the record so far is that Tammy had not worked at the school all that long, a couple of years. There's no indication she was preparing for or nearing retirement. And this statement that insurance should be upped, quote, before she retires or at the end of her career, I think makes the statement vague as it would relate to evidence in this case. Also, under 8033, I don't find that this fits in one of those exceptions as the state has argued. It's not a statement about physical health. It's, I think in the context here would agree with the defense that it's really a statement about a financial decision. And so based on that analysis, the court is going to exclude the statement on the motion in limine. The state would not be permitted to introduce that statement in the state's case in chief, as I would find it would be impermissible hearsay. However, that does not rule out it potentially coming in later, either in the form of impeachment or if somehow the defense were to open the door to make the statement again relevant for impeachment or other purposes. So that's going to be the ruling as to the state's first motion in limine, denying the motion without prejudice to have it re-raised if it comes up in either impeachment or from the door being opened by the defense. The next motion had two separate statements that were sought to be introduced. And this is the March 14th motion. The first statement is a statement where Tammy Daybell told Janet Anderson that Chad had told Tammy, quote, "She is a zombie." And the state indicates that statement was made sometime late August up until October of 2019. So there's multiple layers of this statement, what Chad said to Tammy, Tammy said to Janet. When the court has gone through the analysis of this, it may be permissible on Chad's statement under statement of a party opponent or under Rule 801 D2B. That part may not be hearsay. However, then Tammy telling it to Janet, I think clearly does become hearsay when you get into the multiple layers of the statement there. The issue the court has in addition there is the timing, quite frankly, of the disclosure, noting and agreeing with what the state argued that sometimes even on the stand, witnesses will suddenly say things they hadn't reported to officers, and it's still maybe credible and truthful, and the jury can decide that. However, in this case, looking at the fact that it is a hearsay statement, apparently this witness was interviewed first about 4 years ago, May of 2020, and then the statement just came up in March of 2024, almost 4 years later. That is a concern. Further, the actual statements and how they were made were, the brief said were attached as an exhibit B to the motion. And to the court's knowledge, I don't have exhibit B, so I just don't know exactly what was being said. But looking at the multiple layers of hearsay here, I don't find that it's fitting in any exception to allow its admission in the state's case in chief. And also, I think it's problematic, the timing of when the statement occurred and was disclosed. And so the court is going to preclude the admission of that statement from Janet Anderson about, quote, she is a zombie. Also noting that the statement, even when it was made, at least according to the motion, was sometime over a 3 or 4 month period, which again, I think goes to the credibility of the statement of the court weighing out whether or not this would be a statement that would be more probative than unfairly prejudicial under a 403 balancing. So the court is going to exclude that statement from Janet Anderson. Again, though, it may become admissible in impeachment, or if the defense somehow opens the door to bring that back in. But in terms of the state's case in chief, it won't be permitted to be brought in as being inadmissible hearsay. The last statement in the second part of the March 14th motion in limine relates to a statement that the state seeks to introduce from a witness, Pam Peebles, who was a coworker with Tammy Daybell, and the statement that Tammy told her, quote, "This is the best I have ever felt in my life." And that, quote, she was excited about getting ready for a race. That's a statement purported to have been made 2 days before Tammy's death. The court does find that that particular statement, I think, clearly fits within 803.3, which allows an exception to hearsay for a then existing mental, emotional, or physical condition. The statement of the declarant's then existing physical condition, such as bodily health, is permitted, and that is a statement clearly about her health and would fall within the 803.3 exception. And also on a 403 balancing, its probative value is not outweighed by unfair prejudice. This is an issue that's already been raised by other witnesses, and a defense has crossed those witnesses, also further bringing up the issue of what was Tammy's health at the time before she died. The statement's also made in a narrow enough time frame to make it relevant as well, so the court will permit the statement from Pam Peebles if the state wishes to introduce that in its case in chief. So those are the rulings on each of those 3 evidentiary matters. Does the state have any questions on the rulings, Mr. Wixom? Any questions from the defense?
No, Judge, thank you for your time and effort in this matter.
Okay, thank you. We'll just issue a very brief order referencing the court's findings on the record on those matters. So that's in the case. That'll conclude the ruling for this morning then. In terms of getting going on evidence, I'm not sure where if the jurors were coming in late, or would they be ready to be brought into the courtroom now?
Fine, we're ready to go.
Okay. If the parties are ready, we said we'd start at 9. We're a little early. Is the state okay to proceed, or do you need a minute?
I think we need a moment, Your Honor.
Okay, so you want to just start evidence at 9 o'clock?
If we could do that, Your Honor, that would be great. Thank you.
Okay, and that's what I mentioned yesterday, so we'll go ahead and get on the record at 9 with further evidence. We'll take a brief recess until then. I will note to the parties also, I did receive the juror affirmations from all the jurors this morning, and they're all here and have signed their affirmations, so we'll get started at 9 o'clock.
All rise.